Welcome to the John A. Wilson Building. I would like to acknowledge many members of the public safety team in the District of Columbia. Let me start by recognizing our federal partners in the U.S. Attorney for the District of Columbia, Channing Phillips. Thank you for being here, Channing. And also Nancy Ware, who is the leader of CSOSA in the District of Columbia, that's responsible for supervising federal inmates who have returned to the District of Columbia, and Cliff Keenan, who is the leader of our Pretrial Services. And I think I have acknowledged our federal partners and our local partners, of course, in public safety in the district, as the Attorney General for the District of Columbia, Carl Racine, as well as members of the council who have been very supportive of our Safer, Stronger agenda for Washington, D.C., starting with Kenyon McDuffie, who's the outgoing chairman of the Public Safety and Justice Committee for the Council, and also Charles Allen, who is the now chairman of the Council's Committee on Public Safety and Justice, and of course members of my team who are here: the City Administrator Rashad Young, as well as the Deputy Mayor for Public Safety, Kevin Donahue, who is behind me, and the Chief of Police, who is also with us as well. So let me get started with a couple of things before we turn to the signing of the bill, and we'll also hear from the U.S. Attorney. We, as you know, as many of you have reported, the district ended last year with declining crime rates. We saw a 17% drop in homicides, a 17% decrease in burglaries, and a 13% decrease in violent robberies. And this progress occurred at a time where many other cities did not see those improvements. We were able to bend the curve in the district through hard work of our police officers, and I would like to thank, with all sincerity, the members, the men and women of the Metropolitan Police Department who have worked so hard in all of our neighborhoods to get the job done. My administration has also moved several initiatives, investing in programs that work to stabilize communities affected by violence and to make our police department more efficient and effective. But we know that there is more work to do in 2017, and we are proud to stand here together to get the job done. Today, we are announcing a new tool to help us build on our progress in fighting crime and to remedy one of the parts of our system that is broken. And over the course of the last year and beyond, you've heard me say the council, the U.S. Attorney, and all of our other partners, we have looked for ways to make our system more robust. And many of us have read disturbing accounts of what can happen when there is a lack of coordination and criminals take advantage of gaps in the system. So today, we are here to close one of those gaps, one that has allowed individuals equipped with electronic monitoring devices to go unpunished for removing, disabling, or otherwise tampering with those devices. Electronic monitoring devices serve as a significant tool in monitoring offender compliance and are very important to public safety in Washington, D.C. As the law currently stands, only the United States Parole Commission and the Superior Court for the District of Columbia have the authority to impose the wearing of an electronic monitoring device. Other agencies, like our court supervision partners, may order an offender to wear the device, but these agencies lack any enforcement authority. So today, we are closing that significant gap with the signing of this law. I moved this law, and I want to thank Councilmember McDuffie for introducing on my behalf an emergency as part of our fall legislative package. And today we will sign that emergency into law. So with today's signing, an agency with monitoring authority over an offender can order an offender to be equipped with an electronic monitoring device, or we just usually refer to it as a GPS device, and enforce the order. And those individuals who choose not to comply with those orders will get up to 6 months months in jail. So this creates an opportunity and an important deterrent, and ensures that offenders who tamper with these devices will be held accountable, and that makes it perfectly clear to the courts. In developing this legislation, we worked closely with the Office of the United States Attorney to ensure that we were creating a policy that directly addressed this gap in the GPS monitoring system. Our legal teams poured through data and reports to craft sensible legislation that allows those with the authority to order an electronic or GPS device to also have the authority to enforce that order. So moving forward, devices that are removed, disabled, or otherwise tampered with, the law will state that there is a clear cause for action. Many offenders, and I want to be clear about this, wear these monitoring devices. They comply with the terms of their release, and they take the necessary steps to fully return to their families. So they are taking advantage of the second chance they're beginning. But this law is for those who choose not to comply, and we need to be able to act swiftly, and this law gives us the tool to do exactly that. We are committed to building a safer and stronger Washington, D.C. by using the space and authority we have in the criminal justice system to get to work, to close gaps, and to deliver safe neighborhoods and second chances where they are earned. So I want to thank you all for coming here, and I want to turn to the U.S. Attorney for any remarks. We'll sign the bill, and then we'll take some questions.
Thank you, Your Honor. And good afternoon. Happy New Year to all of you. I want to first thank Muriel Bowser for her partnership with the United States Attorney's Office, as well as our many law enforcement agencies who are here today, including the Metropolitan Police Department, the Office of the Attorney General, Pretrial Services Agency, and CSOSA. I'd also like to express our gratitude for your leadership, along with that of the District Council, in signing and passing, respectively, a legislation that should effectively, as you have heard, close a small loophole in the tampering with a detection device statute. The passage of this amendment, as you've heard, now makes it clear that a person who is required to wear an electronic monitoring device, whether it be by a court or any agency, for purposes of incarceration, commitment, protection order, supervised release into the community, probation, or parole, can be prosecuted for intentionally removing or tampering with the device. Prior to this amendment, the Court of Appeals had interpreted the statute to provide that a person could be prosecuted for tampering with the device only if wearing the device was a condition of his or her release. In the court case that served as the impetus for the passage of this amendment, the GPS device at issue had been placed on a parolee not as a condition of the individual's release, but rather as part of a graduated sanction program by CSOSA. The parolee had cut the device from his body and was initially successfully prosecuted for his conduct, only to have that conviction reversed by the Court of Appeals, which, looking at the plain language of the statute, found that the parolee was not required to wear the device as a condition of parole. So what this amendment does today, by deleting the phrase "as a condition of" and making a few other technical revisions, we believe reflects the District Council's original intent when it enacted the statute, provides both a compliance and deterrent tool through the strength of criminal sanctions, further bolstering the efforts of agencies such as Pretrial Services Agency and CSOSA. Third, restores the ability to effectively use electronic monitoring as a least restrictive alternative to detention or incarceration under appropriate circumstances. And lastly, enhances public safety by using advances in technology to help prevent monitored persons from committing new crimes. Thus, we are delighted by today's signing of the amendment, and once again thank the Mayor and the District Council under the leadership of former Chairman Kenny McDuffie for getting this done. Thank you so much.
Thank you. Thank you. Okay. Let's read this right here. Thank you. I want to thank everybody for their partnership in doing this. All right, very good. Thank you. Okay, we're available for a few questions. Yes, Matt.
Mayor, I just want to ask you a little bit about the Judge McCauley case. So many people across the city still are talking about this. Last week, one of her friends who was in court said, "We feel like the justice system is broken in this case." The deputy mayor came to Fox 5 last week and talked about this issue between CSOSA and with your administration in the city. What is going to be done? You signed this piece of legislation, but can you tell folks what will be done in the future to make sure you're working together to alleviate some of these problems?
Sure, and we're certainly devastated by any loss of life in our city, and we were together where I expressed our deepest sympathies to the families and friends of Ms. McCauley. And this piece of legislation has been moving since the summer, where we identified the gaps, and so I would not necessarily link what we've done today to Ms. McCauley's case. As you know, in Ms. McCauley's case, the offender had not gotten the GPS device. And even if he had the GPS device, that doesn't mean that he and Ms. McCauley would not have crossed paths and we would be suspecting him of her murder. So I don't want to link the two or suggest that that any person who is trying to defeat and commit a crime like the one that was committed in this case, we shouldn't link the two. So let me start there. But we do know from Ms. McCauley's case, I think that we have identified a very significant space for improvement. So how can we make sure when an offender is ordered to get a GPS device, that offender gets it immediately? So one thing that the deputy mayor and our Department of Corrections will work on with our federal partners is making space and time available in our jail, if that's what their first landing spot, for the supervising agencies to have their staff available to put on the GPS monitoring devices.
Can I follow up with that? The deputy mayor said you might talk to the new Trump administration on making sure CSOSA, because they answer to the President of the United States, I think you've said that in the past, works with the district in a better way to make sure these things don't happen?
Well, certainly we regard public safety for Washington, D.C. as a local responsibility. And I think that we're always going to think of ways, even before we become a state, to make sure that we have more local influence on what happens with people who are accused of crime and how they go through the criminal justice system. One such partnership we announced a few months ago. The U.S. Attorney and the Attorney General for the District of Columbia and I were together, and that partnership, I think, is already underway, where we committed local dollars to hire additional attorneys in the D.C. Office of the Attorney General, where we might share attorneys with the U.S. Attorney's Office so that we can have more swift attention and more, quite frankly, training for our attorneys to help in the prosecution of violent crimes in the District of Columbia. So that's one way to go. Now, we will, in our discussions with the new administration, make sure that they know what their responsibilities are and make a better connection between how local residents feel and how the federal agencies respond. So that is always a topic for conversation, and it would have been with any incoming president. Yes.
From Mr. Phillips, if I could ask you a question. The suspect charged with Ms. McCauley's death was out on the street. When he was presented in C-10, the judge went out of her way to say from the bench that the reason he was released was because your office was not prepared the day he presented for trial on another charge. My question for you and your office is, do you feel any responsibility for her death, the fact that he was on the streets, and why was your office not prepared that day when he was presented on a much lesser charge?
Let me begin by echoing what the mayor said. As the United States Attorney's Office, we feel a great loss for the city and for the family members of Ms. McCauley. No question about that. I'm not going to get into specifics in terms of what had happened in this particular matter. As you know, this case is before the courts as we speak. The defendant has a preliminary hearing, I think, set for next week. There was a quick turnaround in terms of the case that was in the court, and communications were made to try to get the witness that was available, or needed rather, for his detention hearing. As to whether or not those communications were actually received is unclear at this point. But we feel a huge loss, and we extend our deepest sympathies to Ms. McCauley's family.
So it was the witness was not available. That was the reason that you guys could not. Thank you very much for that. So I guess I'll ask another question. So how do we close this gap? The two gaps that seem to remain in one, that a suspect or defendant can take off a GPS and not have that notified immedately to law enforcement or pretrial services to swear out a warrant and get him back, or even have a step back to get him back into jail for violating that, sometimes I think for weeks or more. And then the gap that you pointed out, that they're allowed to leave the court without getting the GPS device installed.
We're working on both, especially where our agencies are involved at the Department of Corrections. And we had some discussion. I'll ask Deputy Mayor Donahue to come up to talk a little bit. We do think that there can be some improvements with information sharing between the federal agencies and the district as it relates to GPS violators. And we will continue to work on coordination. Certainly, you know, when I pull all of our public safety partners together, we're always talking about making sure that the people who don't comply, what it means to be out on GPS is you otherwise would be in jail in most cases, but for the decision to let you come back to the community earlier. And in exchange for being able to come back to the community earlier, you have to comply with the terms of your release. So we've had this discussion before. In this case, we're talking about GPS. In other cases, we've talked about people who are out and who have illegal guns. And so there's a lot of things that we want to send a very strong message for. If you want, and we want people to come back to the communities earlier, because largely when we get them back, and we'll have some initiatives at our DC jail to try to get federal prisoners back to the DC jail earlier, so we can better serve them. But people have to be compliant with the terms of their release. Kevin, do you want to talk a little bit more about information sharing improvements we think we can make?
Sure. There's two ways that I would ask you to think about how we need to look at how to better share information. So first of all, information sharing does happen. And it's a two-way street. It's information that MPD needs from federal partners and information that federal partners needs from MPD, as well as the Attorney General and the U.S. Attorney's Office. So on a day-to-day basis, we want to look at how we can make sure the speed of information gets processed more quickly. So when there's a flag raised by a federal partner, we make sure that MPD has that information swiftly. When MPD raises a flag, perhaps there's a lever that a federal partner has that MPD doesn't, that information gets passed as swiftly as possible to the federal partner. That doesn't mean this doesn't happen. It happens every day, but clearly cases that are raised require all of us to look at how we can do better in doing that. There's another way that you should think about information sharing, and that's not looking at the day-to-day. It's looking at our ability, and our ability includes everyone here, to be able to look back at programs that we have and really do evaluations of what we're doing. Quite frankly, what everyone's goal is that if someone's doing their job, their part right as a city, we provide opportunities for them to have a second chance. And that if someone's not, that we hold them accountable. And this all leads to reduced recidivism on the part of particularly violent offenders. We have programs that the federal partners have, that the city has, that we need to make sure we evaluate properly. And what that means is that if there are programs that have been going on for a number of years, that we share data sets. This isn't looking at individual any one person's individual information, but we need to be able to look at data sets that might exist at the court system, at MPD, and Pretrial Services and CSOSA and make sure without violating anyone's privacy, we do evaluations on what works to reduce recidivism so we can reinvest in those things and what works and is effective in holding people accountable who are in fact violating terms and conditions of their release. So our emphasis is on the day-to-day, but also doing some thoughtful evaluations about what seems to work or not work in reducing recidivism.
Last question, Aaron Davis with the Washington Post.
Mayor, kind of two-part question here. You said a minute ago that you think that second chances need to be earned or something to that effect. Can you elaborate on that? And there's so many things we've talked about, written about this year, being the Youth Act or this GPS, that it's a second chance. What do you mean by these second chances need to be earned by offenders? And then secondly, the Public Defender Service and the ACLU have said that they consider this measure on the GPS to allow CSOSA to have the authority to require those to be placed on as a sanction, but that's unconstitutional. So be it the mayor or the U.S. attorney, how do you plan to challenge that or see if that stands up in court?
Well, we haven't been challenged, and we'll see them in court because we're going to move forward and we're going to sign this into law. We expect the U.S. attorney to prosecute, and we expect the judges to render penalties as it relates to the tampering with these devices. So we will be prepared for that. As it relates to earning second chances, this is what we talk about all the time because when we have crime, there are penalties, people serve their time, and when they serve their time, they get to come back home. And that's how it works. And sometimes people will get a 1-year sentence, 6-month sentence, 30-year sentence, but in all of those cases, they are coming back to more than likely to the city where they left, to their families, to society. And so it is incumbent upon all of us, if we want to have a city that's fair and safe, to make sure that we are putting systems in place that allow people to return and to be productive and not to return to a life of crime. So when I say second chances are earned, that's mean a person has done their time, but part of their time is that period of time when they return back to the District of Columbia where they may be on a GPS device, and they have to comply with the terms of their release.
Mayor Bowser, on another note, it's been 10 days since an officer-involved shooting on, I believe, Christmas Day. Your pattern has been within 10 days to release the body cam video.
No, my pattern is to release it at a point in the investigation where it supports the administration of justice. That's my pattern.
Which in the past has been 10 days.
And it could be 10 days.
And so can you tell us when do you think you'll release that video?
We are very close on our end in the district of doing all the things that we need to do to make a decision about release. Part of that process, as you know, is a consultation with the Attorney General for the District of Columbia and the U.S. Attorney. And to the best of my ability and where I think it makes sense, I work with them on any concerns that they have. It is my intention to make some decisions about that very soon.
Thank you, everyone.
Has the family seen the video?
Thank you, everyone.
I understand that they saw it last week.
Thank you. Thank you, everyone.
Thank you. Thanks, the